Good morning, ladies and gentlemen. It's always my pleasure to be with a young generation like you. Because I spent more than 30 years in the academia, so whenever I have an opportunity like this, I comfortably feel at home. As if I became a professor of law once again. Today I'll spend a few minutes to give you a general rundown of the International Criminal Court, and then you may ask me all kinds of questions later on. The International Criminal Court, with its founding treaty, the Rome Statute, has been a reality, as you know, for in the modern world order for more than 12 years now, with its broad criminal jurisdiction over individuals that have committed the gravest of crimes under international law, namely war crimes, genocide, aggression, and crimes against the humanity. It follows the monumental precedents of the International Military Tribunal in Nuremberg, as well as in Tokyo in 1946, and the UN criminal tribunals for the former Yugoslavia and Rwanda. With the 123 states parties today, the ICC's legal protective span has been steadily growing over the years alongside the legitimacy of the institution itself. I have with the Nuremberg and Tokyo tribunals, international criminal law began to emerge as a distinct field of international law. It's very new, actually, younger than the age of most of yours. The two tribunals' significance is that for the first time, justice and the judicial process were placed at the heart of the resolution to an armed conflict. The punishment of individuals was treated as a fundamentally important aspect of ensuring a sustainable peace established on the basis of respect for the rule of law. So in order to institutionalize the legacy of these tribunals, the UN General Assembly tasked the International Law Commission, we call them ILC, to formulate the Nuremberg principles. You know, in the Western Europe, they seldom refer to Tokyo trials. They seem to rely almost always or almost entirely on the Nuremberg rather than Tokyo. So ILC was asked to formulate so-called Nuremberg principles and to prepare a draft code of crimes against the peace and security of mankind, and the ILC did in 1950. But we had to wait for another half century until this whole idea was revitalized in 1989, thanks to the initiative taken by the Trinidad and Tobago. At that time, the Prime Minister of that country was Arthur Robinson. So we honored him very greatly. So much so that our main courtroom in the ICC building is named after him. It's Arthur Robinson Room. And when he passed away, I flew all the way to Port of Spain to attend his funeral. Since the revitalization of all this idea in 1989, 160 states participated, along with the numerous international organizations, regional organizations, and non-governmental organizations. And on the 17th of July 1998, the Rome Statute of the International Criminal Court was finally adopted. This is very significant because the treaty-based nature of the ICC enhances its independence and its legitimacy. In addition, the ICC has become a permanent, readily available court with broad jurisdiction. These characteristics increase both its ability to punish crimes and its potential to deter these horrible crimes. You can easily compare this treaty-based nature of the ICC with other UN ad hoc tribunals, which are based on simply the Security Council resolution. That's why they are ad hoc. As you know, there are 18 judges at the ICC who are elected for only one term of 9 years by the Assembly of the State Parties. I am in strong support of this, the term of office. This is a huge innovation which wasn't easy to achieve, because elsewhere, once judges are elected, then they can stay there for the rest of their life as long as they can be re-elected. One term after another, one term after another. But here with us, with the ICC, it's only for one term of 9 years. I just love that, because that way we should give some opportunities to the rising generations. It's not a monopoly for the old men like me. So it's, you see, this is a very significant innovation, and it also changes the atmosphere of the entire institution. As you know, these 18 judges are organized into 3 divisions: pre-trial division, trial division, and appeals division. For the first 12 years, the composition of the ICC has always been dominant with the female judge majority. You see, 11 women and 7 men. You see, it's not matter of just majority by 1 or 2 seats. It's 11 and 7. This is also the first case of its kind in the history of international court. Elsewhere, for example, the ICJ, there had never been any female judge until Mrs. Rosalind Higgins was elected to the bench of the ICJ in the recent years. You see, now they have 3 over there. That's the maximum. But with us, there's still many women judges, which I like. This also changes the atmosphere of this institution, and the operation is quite different from that of many other international courts. I don't mind, even if a male judge like me might one day become an endangered species in this international criminal justice area, but still okay. And all these 18 judges, no matter where they are from, are actually aware of the compelling needs to protect women and children more than anybody else, because they realize women and children are the most vulnerable victims of the armed conflict. Every 3 years, the 18 judges sit round to elect a president and two vice president for a 3-year term. They may be re-elected for another term, no more. So maximum of 6 years, which was my case. The presidency, which is composed of a president and two vice presidents, is responsible for the proper management of the court. In this case, management would mean to include personal management, judicial management, budget, financial management, and things like that. And the president has, in addition, very demanding, busy, extensive external responsibility or diplomatic responsibility, ceremonial responsibility, representative responsibility, legal responsibility, judicial responsibility, and administrative responsibilities on behalf of the court. As you know, the office of the prosecutor, which is headed by the prosecutor, and she, or the prosecutor, is also elected by the state's parties. Although the office of the prosecutor is under the same roof or in the same building, the prosecutor acts separately as an independent organ within the ICC framework, although prosecutor is subject to the quite strict judicial scrutiny. Defense counsel, I cared a lot about defense counsel during my incumbency. Defense counsel are external to the ICC, so there is a tendency for these crowd to be rather ignored in many ways, which is not fair. They are appointed by suspects on a case-by-case basis. The ICC maintains a long list of counsel, I think more than 400 lawyers from around the world. A long list of counsel willing to accept appointment to cases. When the accused they cannot afford to pay for counsel, then the ICC will pay the cost of the defense. In addition, victims may be represented in court through a legal representative. This is also a lawyer who, where appropriate, is also remunerated by the ICC. So from the very first day, we, the ICC, developed quite complicated but effective legal aid schemes. You know, even if you are, you were the head of state in your country before you were brought to the Hague prison, they always maintain, I have no money. I'm completely broke. You know, I have not even a penny. Even former vice president of the Democratic Republic of Congo, said, "I have no money." But when he was arrested in Brussels airport, he landed there in his own private jet. We know his yacht was moored in the nearby river. We know he has a huge house in various parts of Belgium and elsewhere, and former Portuguese colonies in Africa and elsewhere. And recently we just discovered more than 2 million euros hidden in his bank account somewhere in such a country. I would not reveal the name of the country. But he maintained that, I have no money. So this is also a problem or obstacle to smooth running of the legal aid program by the ICC. Before a case is developed against a particular individual, investigations start with a general situation, general country situation in which crimes may or may not have occurred. These situations may come before the ICC in one of three ways. That means there are three triggering mechanisms under the Rome Statute. One, a state party may refer a situation to the prosecutor. It's a kind of self-referral. Two, the Security Council may refer a country's situation to the ICC prosecutor. Or three, the ICC prosecutor may begin an investigation proprio motu, that is to say, on her own initiative. Prior to deciding whether to commence a formal investigation, the prosecutor first carries out what we call the preliminary examination. Please notice the careful choice of the legal terminology between investigation and examination. Based on the information and communications received, the prosecutor looks at the alleged crimes, jurisdictional requirements, and pendency of any national proceedings in accordance with the principle of complementarity. Only if she concludes that there is a reasonable basis to open an investigation, then she goes ahead and does that. If she wishes to open an investigation, formal one, on her own initiative, prosecutor must make an application to a pretrial chamber of 3 judges. We deliberately coin the words or choose different terms for the Rome Statute. So in this case, under the normal Anglo-American jurisdiction, you might say, a prosecutor must file a motion with the court, or something like this. But we never use that expression here. Prosecutor must make an application to a pretrial chamber of 3 judges. If the chamber concludes that there is a reasonable basis to commence an investigation, then it will authorize the prosecutor to do so. So far, prosecutor has decided to initiate investigations proprio motu in 2 countries, Kenya and Cote d'Ivoire, with pretrial chambers authorization. Following investigation, a situation becomes a concrete case when the prosecutor applies to pretrial chamber for either an arrest warrant or summons to appear for an individual suspected to be responsible for Rome Statute crimes. Most importantly, the current Kenyan president and his vice president and the third accused in the two Kenya cases did appear voluntarily before the ICC. So I think they sent a signal to the world that they will adhere to the procedural rules of the ICC. The next step after personal appearance is what is called the confirmation of charges hearing. At this particular hearing, the prosecutor is required to provide sufficient evidence to establish substantial ground to believe that the person committed each of the crimes charged. The logic behind this more substantial pretrial hearing is to avoid cases going to trial on charges for which the prosecutor has no enough evidence to justify a trial, let alone convict an individual. This sort of filtering mechanism at the trial stage, pre-trial stage, is quite effective. Our practicing experience amply indicates that. I refer to two sort of standards here. At the prosecutorial stage, I refer to the standard called reasonable ground to believe. But when you come over to the trial stage, then I refer to the substantial ground to believe. You see, so the criteria is gradually going up. If, for example, if you want to convict the guy, then what is required? Beyond reasonable doubt. So start with the reasonable ground, substantial ground, and beyond the reasonable doubt. These are three different criteria that are applicable to this whole trial proceedings to convict a person. If the charges are confirmed, the case then proceeds to trial. If not, the prosecutor may still gather some more additional evidence and seek to bring the charges again on that basis. Trials are carried out by a trial chamber of 3 judges who's responsible for ruling on points of law and making fact findings. Trials normally take place in the presence of the accused. Trials in absentia are prohibited. But now, what do you mean by presence in this context? You want to stick to the physical presence alone, or in this digital age, would you allow the accused to appear through the digital mechanisms? How far can you go? This is a challenge that requires wise people's interpretation. Actually, this is an issue, one of the issues raised by the Kenyan president. Why can I be tried through all this electronic mechanisms while I'm sitting in my office in Nairobi? The Rome Statute contains long and detailed list or catalog of the rights of the accused. Right to fair trial, right to speedy trial, right to the transparent trial, or just full protection, just everything you can think of. During the trial, judges determine, among other things, in each case, how legal representatives for victims may participate in proceedings. It is quite innovative that the Rome Statute allows the victims to participate in the criminal proceedings, to express their views and concerns. This is very significant. Although it might have the risk of complicating the entire criminal process, but still we have to give the victims some opportunity to express their views and dispel at least their angers or vengeance, a feeling of vengeance or something like this. The appeals chamber has also recognized that victims may, under certain circumstances, introduce evidence, question witnesses. They are almost like a party. They can bring evidence. They can question witnesses. Yes. This is a full-fledged party to the proceeding, almost a party. And then they also testify on their own behalf, as long as the rights of the accused are safeguarded. If the accused is found guilty, again, notice that we use the term the accused. We never use the term defendant here. If the accused is found guilty, he or she will be sentenced by the trial chamber. The ICC may impose sentences of up to 30 years, or in the exceptional circumstances, life sentence. There is no death penalty. Until today, the court has, as you know, issued 3 trial judgments, resulting in 2 convictions and 1 acquittal, all in the DRC situation. From the pretrial stage, victims have the right to participate directly in proceedings, even when not called as witnesses, and to apply for reparations. The judges may also make a reparations order, including restitution, compensation, and rehabilitation. Such reparations may be paid directly to victims or through a trust fund for victims, which has been established for the benefit of victims. As I will explain later, the trust fund and its active operation are truly an unprecedented innovation for restorative justice. The appeals chamber comprises 5 judges, including the president of the court. It may hear appeals against the final judgment of the trial chamber or against the sentence. In addition, the appeals chamber may hear what we know colloquially as interlocutory appeals. It's essentially procedural objections. These appeals may concern questions related to the legality of the proceedings or admissibility of a case, decisions granting or denying the provisional release of a suspect of an accused, or any other issue, the immediate resolution of which is considered necessary. After the first 12 years of the ICC's existence, a couple of fundamental issues have crystallized as the main and major challenges for the court, as the center point of the evolving international criminal justice system, in order to maximize its reach and effectiveness. Challenge number one has to do with the universality. To make the Rome Statute system truly comprehensive, the ICC must achieve universality. Out of 193 countries that exist on the globe, still 70 states have yet to join, including the world's most populous countries such as this country, India, the US, Indonesia, and Russia. Often, in my view, the state's hesitation to ratify the Rome Statute is based on simple misunderstandings of how the ICC operates. I numerously emphasized and told the government leaders that we ICC operates on the basis of two fundamental principles. We operate on the basis of non-retroactivity. We don't go back to the past to dig out the old scars. To join the ICC means to look to the future. It doesn't mean to go back to the past. They refuse to believe me. The other principle, the ICC operates on the basis of complementarity. It is primarily your individual country's responsibility to conduct a genuine investigation and prosecution to punish these horrible individuals who committed these horrible crimes. Only if you don't want to do it, only if you cannot do it, then only then ICC will step in. So it's primarily your responsibility. This is all about the complementarity. You know, otherwise, the leaders have a lingering suspicion about the ICC and fear. Hey, you guys might just jump over and intervene in our judicial process. This is a fundamental hidden fear they all share. We said, this is primarily your responsibility. If you don't want to do it, you cannot do it, only then we will step in. And they don't say, they don't believe this. As long as your judiciary, your legal system, police, military police, or prosecution, or court function normally, there's absolutely no necessity, no possibility that the ICC will cross the national border and just stir the normally functioning the legal system. We don't have that much resources and time at all. You do your own job. Only if you cannot do it, you don't want to do it, then we will come in and help you. They don't believe this. And then the second, I just referred to complementarity. So it's still a challenge. Complementarity issues a challenge. And then another challenge, another crucial aspect of credibility and strength of the ICC is a cooperation of states with the ICC and the enforcement of its orders. Since the ICC has no police force of its own, the court relies entirely on states to execute its arrest warrant. The ICC also requires their assistance in the provision of certain evidence, to facilitate the appearance of witnesses, to identify and freeze assets, and for a number of other court operations. But don't misunderstand me. In 9 cases out of 10, the state cooperation are forthcoming. And even non-states like the US is quietly but smoothly cooperating with us very well on the case-by-case basis. And then I'll talk about peace and justice again. Today it is accepted that peace and justice can and must go hand in hand. In particular, the post-World War II tribunals have shown that justice is a fundamental building block of sustainable peace. It may be tempting to argue that it should be the responsibility of courts and tribunals not to upset any peace processes, and therefore not to issue any arrest warrant against mass crime perpetrators because these guys are involved in the peace process. Against this, however, it can be equally strongly argued that to have judges and prosecutors consider political factors such as interests of peace would inevitably introduce undesirable politicization into the legal process. So it's a challenge. And then another one, as a judicial body, the ICC interacts and cooperates with international and national political actors, such as the UN Security Council, regional organizations, and national government. Therefore, it is crucial that ICC delineates a boundary, establishing its place amongst these political bodies without becoming one itself. Luckily, the Rome Statute is quite rigid about this and allows judges and the prosecutor to make decisions on a solid, transparent legal foundation and apply the law. In a concluding remarks, I think the record of the ICC is, in my view, very, very positive, but somewhat mixed. There have been many positive achievements. The ICC has exceeded the expectations in many ways. It came into being much faster than expected, only 4 years after this document was signed. ICC not only survived but thrived despite early opposition by some powerful countries, Bush administration, for example, which sought to discredit the ICC altogether. And the first referral situation by the Security Council came sooner than everybody expected, as early as in 2005. And at that time, also, many observers thought that the US, at least, would veto any Security Council effort to refer a situation to the ICC, but the US didn't. And also, creation of the Trust Fund for Victims is an innovation. The fund not only executes judicial reparations orders for victims, but also operates diverse programs such as medical services, vocational training, continuous professional counseling for rape victims, manufacture and supply of artificial limbs, community-based educational programs for children, peace education, microloan for the former child soldiers, and so on and so forth. ICC is now engaged in a wide variety of situations around the world. The ICC's body of jurisprudence is steadily growing and thereby contributing to the further development of stout body of international law, protecting victims of mass atrocities and deterring future crimes. Of course, at the same time, there are clearly some areas for potential improvement. Judicial proceedings must speed up, for example. However, the biggest challenge by far remains ensuring sufficient cooperation from states, especially with respect to arrest and surrender. It is now up to states to see that ICC has the support it needs in order to carry out its functions and to achieve the goals for which states created it.